So detailed scrutiny of the Digital Safety Commissioner Bill 2017, Private Members Bill resumed. I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the Chairman to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that where possible you should not criticise or make charges against any person, persons or entity by name or in such a way as to make him, her or it identifiable. I also wish to advise you that any submission or opening statements you have made to the committee will be published on the committee website after this meeting. Members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the Houses or an official, either by name or in such a way as to make him or her identifiable. And I remind witnesses and members to turn off your mobile phones as they interfere with the sound system. I'd like to welcome all our witnesses to our meeting this morning, and I'd like to advise witnesses that as there is a large number of stakeholders, I'm going to keep your opening statements to 5 minutes, and I will just indicate after 4 minutes that you have 1 minute remaining. And our members, I will keep you to 3 minutes questioning to our witnesses. So we'll start with the sponsor of the bill, Deputy O'Leary. You might give us a brief overview of the Digital Safety Commissioner Bill 2017. Thank you, Deputy.
Thank you very much, Chair, and I'm glad to be here once again to address the committee on the Digital Safety Commissioner Bill. As I stated on the previous meeting, there's no doubt but that safety online has become one of the most significant challenges facing Irish society and is arguably one of the most significant child protection issues of our times. We face significant challenges and many, particularly parents, are concerned about what is happening there. It is hard to blame them when we read the stories of predatory behaviour, harmful material being circulated and online bullying. It is a challenge which legislators cannot ignore and must face up to. While it is the case that this is an issue which requires a policy response, which requires an educational response, it is also my belief that it requires strong regulation and a statutory office with real powers and teeth. In most areas of policy, we generally accept that self-regulation is no regulation, and I do not see how we could see the internet and the issue of online safety being particularly different in that regard. It is the case that some providers have good mechanisms, but some do not have any. We also need legislation to ensure that where they are not stepping up to the mark and putting in the safeguards, they should be made to. The primary proposed functions of the Commissioner would be, among others, to promote digital safety for all, to support and encourage the implementation of measures to improve digital safety, including oversight and regulation, and a timely and efficient procedure for removal of harmful digital communications. I want to welcome all the organisations, the Department and the industry representatives, and I note that there has been commentary from the organisations and the industry on this legislation. I welcome, I suppose, that in a previous meeting of this committee that Ms Niamh Sweeney and Ms Siobhan Comiskey of Facebook stated that they were not opposed to the idea, that they see great benefit in a single office having the ability to oversee and coordinate efforts to promote digital safety. And I think that is a view that is widely shared, although that there is detail that I do think we all need to work collaboratively and constructively on. And on that point, I will say that I am very much approaching this engagement as the previous engagement with somebody who is open-minded to amendments. I'm not precious about that, and whatever way the bill can be improved, I will work with the committee, the department, industry and civil society organisations to do so. The key points raised last week and I expect today is the need for a definition of harmful communications. It's possible that it would be appropriate for the definition to be provided by the Digital Safety Commissioner's Office, though certainly not, I believe, to be left to the provider to define what this is. However, on balance, it is my view that, given there is a legal requirement to be in compliance with sections 4 and 5, that it would be appropriate to provide a definition. I am developing a draft of a definition. I think it will be necessary. My view, generally speaking, is that we should look to the Law Reform Commission's recommendations. This provided a description of a category of offences already existing and proposed. I am not proposing to introduce as amendments to make them criminal offences in the bill. I do favour that these are the types of behaviours which we must seek to address. I outlined this last week and can elaborate again if required. I will be making a submission to the committee and also to the Minister in the coming period to inform the drafting of the scrutiny report. May I suggest to other bodies with an interest that they could consider this as well, and to allow the committee to evaluate them all in advance of proceeding to committee stage and in drafting the report. The point has been raised also in relation to freedom of expression. I acknowledged this in my comments on the last occasion, and of course it is correct that we must proceed very carefully. Freedom of expression is a value that we all treasure, that is essential to a functioning democracy, but I would also state that, and I will wrap up on this, I do not think that this is any reason that we cannot proceed. It is not a right which is absolute, particularly where harmful communications are damaging, hurtful and illegal in circumstances. I believe there is a consensus. We cannot simply allow self-regulation to be the only approach. We need to be ambitious, imaginative and show vision. There is no reason, given this has been done in other common law jurisdictions, that we cannot do the same here, and I believe we need to do that.
Thank you. Our next witnesses are from the Department of Communications, Climate Action and Environment. We have Ms Patricia Cronin, Assistant Secretary, and Ms Trina Quill, Principal Officer. I now ask Ms Cronin to give your opening statement.
Thank you, Chair. First of all, I'd like to thank the Chair and the members of the committee for inviting the Department here today to participate in the detailed scrutiny of Deputy O'Leary's bill. As members are aware, Minister Bruton expressed his preliminary views on the bill at the committee's hearing on the 25th of October. As the Minister outlined at the previous hearing, he is of the view that if the Oireachtas is to pass a law in this area, it must ensure that it is robust, effective and proportionate and properly meets the public policy need to protect children online. The Minister has asked the Department to consider the private member's bill in detail. The Minister has also asked the Attorney-General for urgent advice on a range of legal issues which the draft legislation presents. As members are aware, the Action Plan for Online Safety, which was published by the Taoiseach on the 11th of July 2018, contains 25 actions to be implemented or substantially progressed by the 6 government departments involved by the end of 2019. Since the publication of the Action Plan, an interdepartmental sponsors group chaired by the Department of Education and Skills with membership from the other 5 government departments has been established. That group will report to the relevant Cabinet Committee on progress in implementing these commitments. The National Advisory Council for Online Safety has also been established and its secretariat is provided by my department. The first meeting of the Council was held on the 4th of October and the next meeting will be held in the coming weeks. Minister of State Canny has succeeded Minister Kine as Chair of the Council. The Committee may also be interested to note that the Council has established 2 subgroups, the first to consider the role of the Council in relation to guidance material and the second to consider the Council's role in relation to research. A wide range of organisations have accepted the Government's invitation to be members of that Council, including the 4 other organisations before you today, as well as other bodies representing parents and older people, academic experts and state bodies including An Garda Síochána, the Data Protection Commissioner and the Ombudsman for Children. It's envisaged that the Council will publish a report on its work to date to coincide with Safer Internet Day in February, which in subsequent years will become its annual report. The overall focus of the Action Plan is to identify and deliver the activities that can be delivered over a period of 12 to 18 months, which will have the greatest impact on online safety for all our citizens, but especially children. Action 18 of the plan commits Government, and specifically my own department, as well as the Departments of Justice and Equality and Business, Enterprise and Innovation, to work with this committee to explore the issues arising in respect of this private member's bill. There are a number of issues which the committee may wish to consider in the context of its scrutiny, a number of which were referenced by the Minister on the 25th of October. These include the absence of a definition of harmful digital communications. It will be important to define what illegal offences will come within the scope, whether the definition would also include harmful but not illegal communications, and if so, of what nature. The definition of a digital service undertaking, which appears to encompass a very wide range of undertakings, some of which pose little or no risk in respect of harmful communications. In relation to illegal content, would the Commissioner have the power to seek the takedown of such material without consulting An Garda Síochána? In the case of harmful but legal content, are there enforcement issues arising given that under the E-Commerce Directive 2000, notice and takedown requirements relate only to the takedown of illegal content? Finally, is the enforcement mechanism envisaged for the takedown of harmful content by an undertaking located outside the state appropriate, given that the speed of takedown would likely be the key outcome sought in such cases? It may be helpful for the committee to be aware of some additional developments in the regulation of online content at European level. It is expected that the final text of the revised Audiovisual Media Services Directive will be published shortly, with a requirement that it's implemented by Member States within 21 months. The original AVMS Directive, agreed in 2010, established the framework for regulating traditional television and on-demand services such as the RTE player and Netflix. While there are many aspects of the revision which will be of interest to this committee, of particular relevance to today's discussion are the new provisions which will apply to video sharing platform services. Aspects of services such as YouTube are likely to fall within the scope of these provisions. The revised directive will require Member States to introduce by means of co-regulation a system of ensuring that these services have measures in place to ensure that minors are protected from audiovisual content, including advertising. The general public are protected from audiovisual content, including advertising containing incitement to violence or hatred. And the general public are protected from audiovisual content, including advertising. These offences are terrorism-related offences, child sex abuse, material offences, and offences of racism and xenophobia. Ireland will be required to appoint a national regulatory authority who will monitor and ensure that these video sharing platforms have appropriate measures in place in order to meet the goals outlined above. Among the measures may be appropriate are age verification control and parental controls. This prevents an alternative approach to the regulation of harmful online content, albeit only for video sharing platforms. The Department intends to commence a public consultation on Ireland's approach to the implementation of this revised directive before the end of this year. Thank you, Chair and Commissioner.
And our next witnesses are from the Irish Society of Prevention of Cruelty to Children. We have Mr John Church, the CEO of the ISPCC, Ms Fiona Jennings, Policy Coordinator of the ISPCC, and I now ask Mr Church to give your opening address. Thank you.
Thank you, Chair, members of the committee. I'd like to thank members of the committee for having us here today and Deputy Donnacha O'Leary for bringing it forward. We welcome the introduction of the bill to establish an Office of Digital Safety Commissioner and look forward to its progress. Online safety is the child protection issue of our day. I'd like to share an example, a typical example of that we see in our Childline cases. A 15-year-old female contacted Childline's web chat service. She stated that she sent nude pictures of herself to her boyfriend, and when she broke up, he sent them to his friends, and now her friends and people in school are talking about her and calling her vile names. She feels really embarrassed, stupid and ashamed. She said that she feels very hurt and betrayed by her ex-boyfriend. She didn't think that he would do such a thing. She said she was terrified that her parents would find out and scared about it, how they might react, especially her dad, as he is so strict. She said she is so upset that she wants to kill herself. This case example illustrates the fear and isolation children feel when something they do online goes horribly wrong and they perceive the situation is out of their control to manage. The ISPCC has been pleased to see the House of Oireachtas take seriously the issues of online safety, with significant increase in activity across government departments in the last year. We'd like to take this opportunity too to acknowledge the work of the Office for Internet Safety and WebWise and the work they do on limited resources. These structures need to be better resourced to make them more effective, and for every parent, child and teacher in the country to become aware of them and embrace their resources and expertise. The ISPCC broadly welcomed the publication of the Government's first action plan for online safety last July, in particular its provisions for enhanced education measures and proposed law reform. However, the ISPCC expressed its disappointment at the time that the action plan fell short in a commitment to statutory regulation. Not long after the launch of the action plan, and indeed in recent times, the public has been presented with stark examples of where self-regulation is falling. It is our experience that these failures can impact negatively on children, and that there are positive actions that Ireland can take to better protect children online. Notwithstanding the commitment to self-regulation in the action plan, and perhaps to reflect the fast-changing nature of this space, we were delighted to hear Minister Bruton's comments at the committee's detailed scrutiny stage, where the Minister stated it was time to move beyond self-regulation and highlighted the need for a regulatory body in the online space. In 2016, the ISPCC carried out an internal case review across our childline service and our frontline services on the prevalence of online safety issues in our work. The findings of this review, along with cases in the external environment, led to online safety being an integral part of our policy work, in turn giving us a clear mandate to advocate for change in this area. In February 2017, the ISPCC presented to the Joint Oireachtas Committee on Children and Youth Affairs and shared our experiences regarding online safety issues. These issues included access and exposure to inappropriate content, online grooming and cyberbullying. Harmful communications among children can be compounded due to the nature of them being children and perhaps not realising the reach their actions can have online. We're in no doubt online safety is a major issue for children and young people in Ireland. In 2005, we launched the first text-based support service for children in Ireland. We've seen a shift in our online and text service over the last decade, and we're in the final stages of development of a new online service. The ISPCC has seen the use of our Childline online service jump from just under 4,000 conversations in 2007 to just under 30,000 conversations in 2017. We know that children want us online and to be more accessible to them in the space they inhabit. Through listening to and engaging to over 1,000 children a day on our Childline service, we've been able to spot trends over the years and raise these issues in the media with policymakers and legislators. Over the past 2 decades particularly, we've seen how children's technological lives are becoming increasingly embedded in their lives as a whole. The online-offline distinction for children is an unfamiliar concept. Utilising technology and being online are no longer an add-on. It is how and where they live their lives. Children make up 1/3 of the internet users globally, 1 in 2 users in the developed world. Children's participation and protection rights in the digital environment are widely supported across EU laws and policies. Irish policy sets out ambitions for all Irish citizens to be connected and online. ICT is broadly available and its use encouraged in many schools. The Government's Action Plan for Online Safety recognised children's specific vulnerability and warranting greater protection. The Net Children Go Mobile report in 2015 found that 1 in 5 children in Ireland reported being bothered by something they saw on the internet in the past. The internet was not created with children as users in mind, but they use it. We know this, and we have all a role to play in keeping them safe online. Therefore, it is imperative we recognise the need for a regulatory body with a Digital Safety Commissioner or equivalent to champion children's online safety and seek remedies for them when they are unable to do so themselves. The issue of defining harmful communications has been raised at the various stages of debate on this bill thus far. It is important that a definition is created to reflect the examples of harmful communications referred to in the Law Reform Commission's report and elsewhere, and not to be overly broad to render the definition unworkable and in effect useless. In conclusion, while some of the suggested work of the Digital Safety Commissioner is being done across other government departments and structures, we feel there is merit in having the coordination of this work to maximise its efforts and impacts for all concerned coming under the office of Digital Safety Commissioner or equivalent. Children have a right to be protected, and this protection extends to being online. Being online is the public space where children frequent the most. They converse with their friends there, keep in touch with family there, they shop there. It is their first go-to place for information, and like any public space, it should afford them similar safety protections. Thank you.
Thank you very much, Mr. Church. And we also have the CEO of CyberSafe Ireland, Ms. Alex Cooney, and I ask you to make your opening address. Thank you.
Thank you. Chairperson, members of this committee, I would like to thank you for the invitation to appear before you this morning to address the Digital Safety Commissioner Bill. For those of you not familiar with our work, CyberSafe Ireland is the children's charity for online safety in Ireland. We set up in 2015, and since then we've spoken to 14,000 children and to thousands of parents and teachers about staying safe online. We also gather data on an ongoing basis, as this enables us to monitor trends and usage as well as to highlight risks. We recently launched our annual report and published the data that we've gathered over the last academic year based on over 5,000 responses from over 5,000 children aged between 8 and 13. 68% of these children own a smartphone and 70% were signed up to social media services and messaging apps, despite age restrictions of at least 13 on all the services. In short, the use of online services was pervasive amongst this cohort of children. Our report further highlighted that many primary school teachers are seeing the consequences of children's online use in the classroom, with 62% of teachers having dealt with online safety incidences over the last academic year. Over a third of teachers had dealt with between 2 and 5 incidences last year. Some of these instances involved the uploading and sharing of harmful and upsetting material, including intimate images. I am providing this data as a context to our position on the Digital Safety Commissioner. We believe that a Digital Safety Commissioner will offer a level of coordination and oversight that we don't currently have in Ireland. It will furthermore introduce a level of accountability by helping to ensure that social media companies are timely and responsive in their removal of any harmful material and consistent in their application of safeguards by providing monitoring, oversight and reporting on their performance in this regard. As a charity that is often approached for help by parents, teachers and those working with vulnerable children, we're more aware than many of the reality of when things go wrong online, when harmful or upsetting content is not removed or is not removed quickly enough. We also know that self-regulation means that online service providers get to be judge and jury in cases of troublesome and sometimes controversial content. This is where a Digital Safety Commissioner can play an important role in the review of materials and decision-making around takedown procedures. The bill also proposes introducing a code of practice which would mean that there was greater consistency across platforms. The Office would also have an education and research remit and would offer an important level of coordination in these areas. It's important to recognise that many of the leading social media platforms, including Facebook and Google, have worked consistently to improve safeguards on their platforms, and that they have in addition provided some useful educational resources. It's incredibly important that they continue to prioritise safeguarding practice and design into the future. We believe, however, that we need to go one step further by ensuring that all platforms are held to the same high standards and that there is a regulatory body that can provide oversight and can step into the breach when needed. It's helpful in any discussion about a proposed Digital Safety Commissioner to consider the precedents. The Australian Office for the E-Safety Commissioner was set up in 2016 as a result of the Enhancing Online Safety Act of 2015. Whilst this office is still new and it's still too early to assess its full effectiveness, commentators such as Matthew Rimmer, Professor of IP and Innovation Law at Queensland University of Technology, thinks that it does offer value and that it addresses, and I quote, genuine child safety issues in the digital environment which haven't been well dealt with by governments or IT companies or the community. The Australian Legal and Constitutional Affairs References Committee also acknowledged the importance of this office in its review of laws relating to cyberbullying earlier this year. It urged the government to ensure that it was given appropriate levels of resources to carry out its mandate effectively. Whilst the UK does not have the equivalent of a Digital Safety Commissioner, it is in the process of developing a new Internet Safety Strategy, which will be introduced before the end of the year and which outlines some similar plans in terms of regulation. The UK government published the results of its public consultation on its Green Paper in May, and one of the findings from the consultation was that users, including children, felt powerless to address safety issues online and that there was insufficient oversight of technology companies as well as a lack of transparency on their part. The Culture Secretary, Matt Hancock, outlined plans to introduce a social media code of practice and transparency reporting as part of its digital charter, and this may well become a legislative requirement in due course. Given Ireland's membership in the European Union, it is important to consider what is happening at European level in order to set these proposals into the appropriate context. In July this year, the Council of Europe made some recommendations to its member states around children's rights in the digital environment. The recommendations acknowledge the importance of children being able to access the online world and include a wide range of measures and proposals around children's rights, but also measures to protect them, including ensuring inbuilt safety by design, privacy by default, and as well as privacy by design and by default as guiding principles for products and services, and particularly those used by children. The recommendations also recognise that children, and indeed those that care for them, need guidance and education. The document states that digital literacy education should be included in the basic education curriculum from the earliest years, taking into account children's evolving capacities. Whilst the recommendations are wide-ranging in nature and there isn't the space to touch on all points here, I'd like to highlight one other piece in relation to them, and that is the need to identify and establish competent bodies with the responsibility and authority to implement actions in a timely and efficient manner, and that such a body should be adequately resourced both in terms of funding and staffing. The proposal for an Office of the Digital Safety Commissioner seems to me to offer several opportunities to meet the standards set out in the Council of Europe recommendations, although it could go further than the current proposals and include reference to the ethical and safe design of any apps and games as recommended by the Council of Europe. We'd also like to see explicit reference to the need to embed digital literacy into the curriculum reflected in the bill. We must equip young people with the skills and know-how to navigate the online world in a safe and responsible manner. Education is an important part of any prevention strategy, and the need for digital literacy to be taught in schools is recognised in both the UK strategy and the European Council recommendations. This bill includes many significant measures, and with some additions, it could provide a strong basis for our national strategy for dealing with online safety well into the future.
And we'll now move on to Ms Niamh Sweeney, Head of Public Policy, Ireland Facebook. You have 5 minutes. Thank you.
Thank you, Chair. I am the Head of Public Policy for Facebook Ireland, and I'd very much like to thank the committee for asking me to be here today. I'll just give you a brief overview. I've been in a few times before, so we've given more lengthy explanations of our approach to safety, but it's worth just recapping in an overview fashion today. Every day, more than 1.4 billion people from around the world use Facebook. They post in many different languages, everything from photos and status updates to live videos. Deciding what stays up and what comes down involves hard judgment calls on complex issues, from bullying and hate speech to harassment. It's why we've developed our community standards with input from outside experts, including academics, NGOs and governments from around the world. Our community standards have been available publicly for many years, and in April of this year, for the first time, we published the more detailed internal guidelines used by our review teams to enforce those community standards. We decided to publish these internal guidelines for 2 reasons. First, the guidelines aim to help people understand where we draw the line on nuanced issues. And second, by providing this detail, it makes it easier for everyone, including experts in different fields, to give us feedback so that we can continue to improve the guidelines and the decisions we make over time. We also have a safety advisory board which is comprised of leading internet safety organisations on child abuse, domestic violence and internet safety for children and women. Facebook consults with these organisations on issues related to online safety and keeping our community safe. For the content review process itself, we use a combination of artificial intelligence and reports from people who use our service to identify posts, pictures or other content that may violate our community standards. These reports are reviewed by our community operations team, who work 24/7 in over 50 languages all around the world. This year we have doubled the number of people working on our safety and security teams to 20,000. This includes over 7,500 content reviewers specifically. We are also investing heavily in new technology to help deal with problematic content on Facebook more effectively. For example, we use technology to assist in sending reports to reviewers with the right expertise to cut out duplicate reports and to help detect and remove known terrorist propaganda and child sexual abuse images before they've been reported. Last month, we also announced that we've been increasingly using artificial intelligence and machine learning to detect child nudity and previously unknown examples of child sexual exploitation imagery. Content review at this scale has never been done before, as there has never been a platform where so many people communicate in so many languages across so many countries and cultures. But we very much recognise the responsibility we have to get this right. I'm here today, obviously, in the context of the committee's detailed scrutiny of the Digital Safety Commissioner Bill. The members will recall I gave an outline of our thoughts on this topic at the August 1st hearing I attended, but I'm happy to be here again today as the committee considers the bill in detail. We understand the motivation behind the establishment of a Digital Safety Commissioner, particularly the appeal of having an independent statutory body that is authorised to adjudicate in cases where there is disagreement between a platform and an affected user about what constitutes a harmful communication, or to provide a path to appeal for an affected user where we have, in error, failed to uphold our own policies. We would also acknowledge the Bill's efforts to ensure that its scope is not overly broad, in that an appeal to the Digital Safety Commissioner can only be made by individuals where the specified communication concerns him or her. And again, we very much see the benefit in having a single office to oversee, with the ability to oversee and coordinate efforts around the promotion of digital safety throughout communities, much of which has been captured in the Government's Action Plan for Online Safety. It's only through this multi-pronged approach, of which education is critical, that we can begin to see positive changes in how people engage and protect themselves online. In its 2016 report, the Law Reform Commission, in addressing the nature of harmful communications, said the following: While there is no single agreed definition of bullying or of cyberbullying, the well-accepted definitions include the most serious forms of harmful communications, such as so-called revenge porn, intimidating and threatening messages, whether directed at private persons or public figures, harassment, stalking, and non-consensual taking and communication of intimate images. We agree with the Law Reform Commission with respect to all of these types of communication, a very stark example of which was given by John Church in his opening statement. The sharing of non-consensual intimate images, NCSII, harassment, stalking and threatening messages are all egregious forms of harmful communication and are banned both by our community standards and, in some cases, the law. And we fully support the LRC's proposals to create a new criminal offence to tackle non-consensual sharing of intimate images and, indeed, online harassment, where those offences are clearly defined and practicable for a digital environment. We've also taken steps to step up how we tackle non-consensual sharing of intimate images that is shared on our own platform. More information on that can be found online, and I've shared the link with the committee in the opening statement. However, as Deputy O'Leary has outlined as well in his remarks today and previously, the proposed bill is currently unclear as to what precisely constitutes a harmful communication. There's no definition included in the draft bill, but it does appear from the draft that it appears that this concept is intended to be broader than content that is clearly criminal in nature, much of which has been touched on already today. And the exact parameters are left undefined, which could lead to uncertainty and unpredictability. But I'd like to acknowledge Deputy O'Leary's remarks today, where he talked about the need to include a definition. We'd very much welcome an opportunity to work with you on that, if that was possible. And previously you mentioned on the 25th of October that you felt that there was a need for legal certainty, and we'd very much welcome that. As the Law Reform Commission wrote in 2016, the Internet enables individuals to contribute to and shape debates on important political and social issues. And within states with repressive regimes, the Internet can be a particularly valuable means of allowing people to have their voices heard. Freedom of expression is therefore the lifeblood of the Internet and needs to be protected. The report continues, balancing the right to freedom of expression and the right to privacy is a challenging task, particularly in the digital and online context. Proposing heavy-handed law-based measures intended to provide a remedy for victims of harmful digital communications has the potential to interfere with freedom of expression unjustifiably and impact on the open and democratic nature of information sharing online, which is the Internet's greatest strength. And again, I know Deputy O'Leary is alive to these issues and referenced them in his previous contribution. I'm going to cut to the end because I know you're under pressure, so I'll just finish by saying that Facebook has put community standards in place for a reason. We want our community to feel safe and secure when they use our platform. We are committed to the removal of content that breaches those standards, and we are keen to continue to engage with this committee and others as the Digital Safety Commissioner Bill moves into the next phase in the legislative process. Thank you.
Thank you very much. And I'm now going to move on to our final witnesses, Mr. Ryan Mead, Public Policy and Government Relations Manager at Google Ireland, and Ms. Rachel Madden, Public Policy Analyst from Google, based in San Francisco. So I'll ask Mr. Mead to give your opening statement. Thank you.
Thank you, Chair, and thank you for your invitation to participate in your session today. As I say, my name is Ryan Mead. I work with Google in Ireland as Public Policy and Government Relations Manager, based in our Europe, Middle East and Africa headquarters here in Dublin. I'm joined by my colleague Rachel Madden, who works as Senior Public Policy Analyst, focusing on online safety and based in our San Francisco office, but hailing from Dublin. Rachel's remit is global and she works closely with our product team, so I'm delighted she's able to join us today. Google very much welcomes the committee's efforts to engage with stakeholders in your consideration of the Digital Safety Commissioner Bill 2017, and we really appreciate this opportunity to outline our views on a number of the issues raised in the bill, which we feel merit deeper consideration by the committee. Before I address the issue specifically, I thought it might be helpful to briefly outline Google's approach to safety online. Google believes deeply in technology's ability to unlock creativity and engagement. We also believe that technology companies have a responsibility to their users, that what is unacceptable offline should be unacceptable online, and that all users should be empowered to manage online risks and make safe choices. We work hard behind the scenes to ensure that our users have as positive an online experience as possible. At Google, our approach to online safety and well-being falls into three main themes: strong community guidelines, technological innovation, and working in partnership. We're a company fundamentally committed to access to information, yet our community guidelines and content policies offer clear rules on what we don't allow on our platforms. These often go above and beyond what's in the law and we employ thousands of staff around the world who work 24 hours a day to ensure violations of our guidelines are acted upon. In terms of technological innovation, Google has aimed to be the industry leader in creating and developing products and tools which help protect and empower our users, and we will continue to invest the resources necessary to ensure families can make safety choices that are right for them. We developed YouTube Kids to offer an alternative YouTube specifically designed for young children. It provides a restricted version of YouTube for families with built-in timers, no public comments, no option to upload content, and the ability for parents to block or allow access to specific channels or videos. Last year, we launched Family Link, which enables parents to create a Google account for their child and then helps them set and tailor the digital ground rules that work for their children, including on-screen time, device bedtimes, and approving or blocking specific apps or functions like the camera. Ireland, in fact, was the first country outside of the US where we launched Family Link, and it has since been rolled out in 170 countries. My colleague Rachel will be happy to speak more about these online safety products which we've developed. At Google, we know that collaboration has been key to ensuring that our products and services offer families a positive and secure experience online. That is why we regularly work with NGOs, government and industry partners to empower parents and children with the tools and skills they need to make the most of the internet. We believe that companies like Google have a responsibility to not only ensure that our products and services offer a great user experience, but that we also work alongside a wide range of stakeholders and industry partners to creatively and effectively raise awareness, offer support on how to navigate technology responsibly, and to share technological solutions to help tackle some of the toughest problems we face. Google has invested considerable resources into these efforts. We have thousands of employees across the company working on these areas. We've included more detail on each of these themes in the written version of our opening statement, which has been circulated. That statement also includes some views and suggestions in respect of the Digital Safety Commissioner Bill, which are drawn from this overall approach, as well as from our knowledge and experience of the practical implications associated with these issues. We would also be very happy to provide a more detailed written submission if that was appropriate, but I can just briefly mention in the time available some of the points we believe the committee should take into consideration. In this I'll be echoing, I think, some things that have already been mentioned by other witnesses. We welcome the recognition that there's a need for ongoing awareness and education regarding harmful digital content. We support an approach that includes national initiatives that serve to educate internet users on what it means to be a responsible online citizen, on the resources and tools available to protect their privacy and safety online, and how to deal with and report cyberbullying, inappropriate content and online abuse. We also welcome consideration of additional measures by government to address the posting online of videos or images with embarrassing and intimate content, often referred to as revenge porn, which amounts to an egregious invasion of an individual's privacy. And again, that's something that's been echoed by other witnesses. We believe it is essential that any new legal framework in Ireland should also reflect and be consistent with the laws governing online services in the EU, and in particular the e-commerce directive. In particular, we would highlight the need for the national legislation to reflect the notice and takedown procedures specifically envisaged in the e-commerce directive, Articles 12 to 14, together with the prohibition on imposing general monitoring obligations that's contained in Article 15. I won't repeat the point on definition, which I think has been made by every witness, but we would agree that a clear definition of harmful communications would ensure legal clarity for all parties, and very much welcome Deputy O'Leary's comments on that. We would say also that we believe the delineation of responsibility between the Digital Safety Commissioner and the Data Protection Commissioner does merit deeper consideration as the bill progresses, particularly in light of the Data Protection Commissioner's responsibility for dealing with complaints by individuals related to their data protection and privacy rights under the GDPR. Lastly, as a general point, we would ask the committee to ensure that any legislation is future-proofed by being as technology and platform neutral as possible. So I'll finish there just to say I hope the committee will take these points on board as you continue your deliberations on the bill. We believe the suggested changes will make the legislation more effective and increase clarity in terms of how it's applied. Thank you for your time.
Thank you very much. And we would welcome any further written submissions and detailed, and that goes for all our witnesses here as we progress through our discussions on this bill. Any input that you could give us in writing would be very much welcome by the committee. I'm going to start with a number of questions for myself, and then I'm going to go to the members of the committee, so if you want to just take note of them. Just firstly, with the department, one of the issues raised last week by Minister Richard Bruton was just to be conscious of the cross between the ministerial responsibility and the role of the Digital Safety Commissioner. And I don't know if you're in a position to elaborate on that. My understanding of what he was saying was that the Minister is there to put forward the policy and to ensure that policy is delivered on, and it wouldn't be the role of a statutory body to do that. I may be mistaken. I don't know if you can elaborate on that. And also in relation to the Australian Enhancing Online Safety Act 2015, have your department had a chance to review that, or has there been any engagement with your counterparts in Australia in relation to that? Because my understanding is that it is working well, but there are common law and jurisdiction issues there that may be similar to us here that we could look at. I'm just going to go through also in relation to the Attorney General's evidence. Would that evidence be made available to our committee in relation to us dealing with this legislation? For Facebook, I take the fact that you've stated previously that you're broadly supportive in principle of a Digital Safety Commissioner. We very much welcome that. And there are some issues around the definitions of extraterritorial, the effect that would have on the legislation. And also, from Facebook's point of view, what has your engagement been with the Australian E-Safety Commissioner? Are you in a position to expand on that here today and how that is working? It seems to be working very well. There's very little conflict. I heard an interview with the Australian Digital Safety Commissioner, and she said that it works. Her engagement with social media platforms has been very good, and it has been quite effective to the point where fines are not always needed, and I don't think she's ever used fines, but her engagement with social media platforms has been very positive. So I'd welcome your views on your interactions with the Australian setup there. And Google, thank you again for Mr. Ryan, or Mr. Mead, sorry, in relation to your comments. You mentioned the fact that you would ask that the bill be as platform and technology neutral as possible, and if you could just expand on that. The ISPCC, have you any breakdown in relation to the most common complaints, those that are? Have you got any figures in relation to what is coming before you in relation to complaints? Is it cyberbullying? Is it, I suppose a breakdown for us as a committee would be helpful. And also in relation to defining, and this is a common thread here, what constitutes harmful communication. And I know it would be difficult maybe for you to formulate that here, but I think that's something that we as a committee would welcome from all the witnesses here to help us with that definition as we move forward with this legislation. CyberSafe Ireland, I note you made reference there that you envisaged the provision of ethical and safe design of apps and digital literacy. And I suppose a concern that I may have is that if this legislation is too broad and the role of the Digital Safety Commissioner is too broad, that they may not end up being able to do, if the remit is too wide, they may be less effective. So it's to, I suppose, to limit it to what this piece of legislation is looking at with online content and keeping, I suppose, a narrow focus, certainly initially, and then if we need to build on that in future years to build on the remit, that could be something that would be done. But I would be cautious about extending that too wide where it's not going to be effective. So just to get your views on that, and also in relation to what constitutes harmful communication and any data that you would have available in relation to that, or any information that you could provide to our committee. So I might start with those, and then I'm going to bring in Deputy Stanley and Deputy Lawless next. Will I start with the department? Could you? Thank you.
Thanks very much. In terms of the questions that you've asked, I'll cover off the policy area and the AGs, and my colleague Trina will cover off the engagement with just the Australian e-Commissioner angle. So just as you rightly say, I suppose the role of the Minister and the Department is to look at the policy context. That will be in both a national and a European level. So in terms, our job is to set legislation, put in the broad policy context, and then in lots of areas then there's some external body set up in order to implement it, and there's lots of examples of that. In terms of the European, there's a lot of European legislation. I suppose the AVMS, the one we've referenced, is the one that's coming down the tracks for us. So our job really is that when that's finalised at the end of this month, it'll be our job really to do the consultation, to take, I suppose, what's in the AVMS, particularly the online safety, the co-regulation in terms of the video sharing platforms. It'll be our job to take, I suppose, the what of what the Commission have set out, and we have to figure out the how, obviously, and the Minister in terms of the how that will be transposed. So clearly then in terms of there, I mean, we will set out the, I suppose, obviously the choices here are either have secondary or primary legislation. So in terms of the primary legislation or the secondary legislation, we will have to decide what will be the National Regulatory Authority on that. I mean, we haven't made up our minds on that. We have to obviously speak to the Minister and he will decide. So, but that will be an important component on it, and then how we transpose the requirements of that regulation. So that is broadly how we do things in this area. And clearly, I suppose the other bit, and a lot of people have alluded to, that there's a lot of players in terms of the online safety. Obviously, there's the Department of Justice in terms of anything to do with terrorism content and how they would manage the transpositions there, and the Department of Business and Enterprise in terms of the e-commerce. So it's a fairly complicated kind of world, the online world, but certainly, I mean, the broad policy context is put in place by government departments. So turning to your second question, just to say that the Minister, who clearly is still relatively new in the job, asked us to write to the Attorney-General to get their advice on certain aspects of the bill, because, as I think Deputy O'Leary recognises, some of it is quite complicated. So the parts, I think, that we've mentioned, we've obviously looked to the AGs for advice on the definition. We've looked for the definition of a digital service undertaking. We've looked for the, I suppose, and how it interacts with the e-commerce directive. And then in terms of, entities that are outside the state, how anything in respect to those entities would be enforced. So we've asked for advice on all that, and we're waiting. I suppose in terms of the advice, we would obviously have to ask the Office of the Attorney-General whether it could be shared or not, because it would be their advice, and they would obviously have to consider things like legal privilege. But certainly we're happy to ask them what would be their view when we get the advice, whether it could be shared or not. So we will obviously come back to you on that. So.
Yeah, and in relation to the Australian Office for Digital Safety, I suppose a key aspect that's worth bearing in mind is the different legal frameworks within which we operate, and particularly in the context of our membership of the European Union. So the e-commerce directive 2000 sets out the limitations on legal liability that applies to digital service undertakings, and as my colleague Patricia commented, that's one of the issues on which we're seeking legal advice from the Office of the Attorney-General. But I think it does need to be recognised that there are differences in the legal framework there that may impact on the capacity of an office in this jurisdiction to operate in exactly the same way as it would in Australia. So that's, I think, probably the key element. There are aspects of that office also which focus purely on children rather than the broader focus of this on citizens of all types, although recognising the particular vulnerabilities of children. But I think the legal liability is a particular issue that needs further reflection and examination.
Okay, thank you. Ms. Sweeney, if you want to come in on those questions.
Yes, it's been a while since I've talked to my opposite number in Australia about how things are working there. I think you're right, or at least my last update on it was that the Commissioner's never actually used her official powers, but that there's a lot of consultation and ongoing work with the platforms. When I did last speak to my colleague about this, I knew there was some early anecdotal evidence to suggest that it wasn't necessarily being used in the way you might have anticipated, and that sometimes the reports were about hacked accounts as against specific instances of harmful communication. In other instances, it hadn't first been reported to the platforms. In our case, Instagram and Facebook, the affected user had gone directly to the Commissioner. Obviously, we'd still work with them directly on that, but it wasn't necessarily working. I think the numbers were quite low, but it was the first year of it, so I don't know where we were for 2017. I think those numbers would reflect how it played out in 2016. But as I say, there's ongoing interaction between ourselves and the Commissioner over there.
If there was any update that you could give us in writing, or that
I can ask,
I think our committee would welcome that, just from your perspective, and obviously we'll be liaising ourselves with the Australian counterparts to see how it's working there, but we'd welcome that. Mr. Mead.
Yeah, just on the final point of my submission about asking the committee to attempt to make the legislation as platform and technology neutral as possible, I suppose I should say that is a general point I make all the time. And I'm not suggesting that this specific legislation is running the risk of being too technology specific. But I do think it's important to bear in mind that when framing regulation, obviously you look at existing practices, existing industry players and how technology is used, but technology by its nature moves along. And I think that if we were talking about this maybe 3 or 4 years ago, the issues such as the use of ephemeral content, where Snapchat or others, where the content disappears after time, might not have been considered when framing a bill of this nature. So it's very much a general point. I'm not suggesting there's anything specific in the bill at the moment that would limit its usefulness in the future, but I think that in any regulation in this space, ideally you would end up with a framework that stands the test of time to some extent. So it's very much a general point, asking the committee to bear that in mind.
Okay, thank you. Might bring in the ISPCC next.
Yeah, if I address just that you asked in relation to the numbers and the sort of the trends, and we are seeing some trends in this area. Just to put it in context, we run a confidential listening service called Childline. So today we'll probably take about 1,200 calls from children under the age of 18 and all the way through the year. So in terms of categorising pure numbers that relate to online bullying, last year we accounted for about 6,000 of those 350,000. However, just to put that in context, we very often deal with the issues caused by bullying in general, of which online would be one. So a lot of our categorisation will be dealing with behaviour issues, together with issues like domestic abuse, sexual abuse, body image, bullying in general. So I think what it's causing us to do is have a look at our stats and how we categorise it. If you look alone at the use of our online platform, last year we've just had under 30,000 conversations compared to 10 years ago, which was just under 4. So this is going to become an issue, and I think we're going to have to look at our categorising of how we categorise conversations. And I suppose if we look at trends in the situation, we often use not only Childline, but we consult with our child support workers in the community, which we do one-to-one counselling, therapeutic interventions. And we also have children's advisory committees set up, that they're voluntary committees. So in those latter two areas, we're seeing a bigger rise, where it's not fully reflected in our numbers.
Okay, thank you.
You also asked about harmful communications and definitions. So I'll ask my colleague Fiona to elaborate.
Thank you. So in relation to defining harmful communications and that exercise that's before the committee, I suppose we would refer to the consultation which the Law Reform Commission had with the young people, and the different themes that they identified as to the issues that they saw as, or behaviours and activities that they saw as being harmful. And then the Law Reform Commission themselves as well, I suppose, brought that information together along with the extended consultations they had, and looked at things like the taking or distributing of an intimate image without consent, setting up false accounts to cause intent or harm, and stalking, etc., to cause with actions that would cause alarm, distress and harm as well. Just to reiterate what my colleague Mr Church said at the start, that we would encourage the committee, I suppose, to have a definition or create a definition that is not overly broad and that is workable. In Australia, in the Enhancing Online Safety Act, while it does pertain particularly to cyberbullying, they have a quite niche definition, if you want, where they look at material that is seriously threatening, seriously intimidating, seriously harassing or seriously humiliating. And also in New Zealand, the Harmful Digital Communications Act, so they don't have an entity like the Commissioner. They would have what they call an approved agency, which is NetSafe. And in their legislation, they look at the communications principles, and they look at things about where a digital communication should not be threatening, intimidating or menacing, or should not be used to harass an individual, and there's several more of them as well. So I think they'd be good starting points to look at creating a definition of harmful communications.
Thank you. And on that same question, Ms. Cooley, in relation to harmful communications.
I would agree with my colleague here that we should look at the existing definitions in the Australian and New Zealand context, and that have been approved and are working in practice, and look to have something similar here.
Thank you. Did you want to come in on something?
Just on the other point that you asked me about the digital literacy and ethical and safe design. So in the Australian model, they do have education as well as part of the remit, just worth knowing, and they do use that function. So the office would do awareness raising with parents, and they would produce resources and so on. So there is that mandate there. And this year, it was just children, their focus was just on children and cyberbullying, but they've extended it to all Australians in 2018. So it's covering, I suppose it's increasing its mandate, and that's one of the comments that's been, and the observations that's been made of it as time has gone on. And there's, suggestions of increasing resources that are made available to it as well. I think it's dealt with 500 cases to date so far.
Thank you. I'm going to bring in other members, and if you want to come in on any of the questions, please just indicate to me and I will let you in. Deputy Stanley.
Thanks, Caroline. And just to, I suppose, to deal with first, the presentation from CyberSafe Ireland and the ISPCC, just in relation to, I suppose the feeling out there is that, and it's a view propagated that the internet has empowered everybody, and we're able to connect with people all over the world, and there's 1.4 million users according to Facebook using it every day. But in actual fact, it's actually disempowered. It has a huge disempowering effect in some ways, in that if you look, there is the point highlighted by CyberSafe Ireland that of the survey in the UK. Where both adults and children felt powerless to address safety online issues. I mean, if you're powerless to address your own safety, that means you are seriously disempowered. And I think that is useful that you highlighted that here today, and in relation to insufficient oversight. And I think the case given by the ISPCC, in relation to the 15-year-old girl, I mean, shocking stuff. I mean, it's a life and death issue that she felt that she now wants to kill herself, and unfortunately we all know, Facebook and Google will talk about communities, their communities. There's no communities of 1.4 billion people. Communities are a different entity altogether, and I think that's a misuse of the word by Facebook and by Google to talk about, their online community. There isn't an online community, but in real communities, unfortunately we know of cases like this and similar to this, where lives actually have been taken over issues, such as revenge porn and, bullying of particularly young people online. And just with that in mind, I suppose it sets the context of what we're talking about here today, and the importance of what Deputy O'Leary has put forward, the intent of his bill here. And the first issue I want to raise with Google. Google talk about, to highlight the importance of education in the presentation, and they're saying that that alone, that the problem that could solve the problem of online bullying. That's what seems to be indicated here. But I mean, education in itself, it won't stop. That won't stop somebody who wants to misuse the internet. And it's a huge challenge. I recognise it's a challenge for your companies as well, challenge for us as legislators to try and deal with that. But I would like you just to try and address that issue in more depth, because I think that just making the statement that, that education alone, and highlighting the fact that education alone, could deal with a lot of this. I think it doesn't do justice, and I don't think that it deals with this in a proper way. Unfortunately, we're going to need strict criteria and legislation and means of enforcing this as well to deal with it. So just ask maybe that Google would deal with that. Just in relation to Facebook, that you outlined that there's 1.4 billion users every day, and at your last presentation here, which I followed the last occasion you were in here in August, if I remember correctly, you highlighted that there's 20,000 moderators or people working in moderating what's online, and obviously that shows. I mean, to me, I was actually surprised by the number of people that you have doing that, but it does show the extent of the problem and the challenge and the whole difficulties in trying to deal with the whole area of trying to moderate what's appearing on the platform. And I suppose to ask you, does this highlight to you the extent of that this is really a problem, that it's it's nearly impossible to deal with. I mean, it's probably one of the biggest challenges facing the company and facing us as legislators and governments, maybe across the world. So does it highlight the need for direct state intervention? And just for Facebook as well, in your presentation, you highlighted the need for freedom of expression, and certainly none of us, I certainly wouldn't be one, as somebody who campaigned against Section 31 of the Broadcasting Act throughout the 80s and 90s, which was repealed by our Uachtaráin Nahéireann, Michael D. Higgins, one of the best things he ever done. I think that, you know, we don't want to limit too much freedom of expression, but I think that, you know, that the whole issue of safety and what should be allowed, you know, obviously there's a line that has to be drawn there. So just wondering, you know, do you believe that should be left to people like yourselves, to private companies and corporate entities to define, you know, what should be tolerated in terms of freedom of expression, or is it for government bodies to do that? And both Facebook and Google might just come back to that. Just well, in terms of the definition of the law reform definition, you know, where that basically it's out, you know, revenge porn, intimidating and threatening messages, you know, whether directed at, you know, public figures or private individuals, harassment, stalking, or non-consensual taking and communication of intimate images. Just I want to add to that, maybe, is that, you know, should fake news, you know, what role should Facebook and Google do in terms of fake news, misinformation about individuals? Because we know, for example, in the case of politicians, you know, politicians have been targeted by this type of misinformation in the past, in some cases with very, very detrimental effects on people, you know, in terms of, you know, false accusations being made against public figures, not just politicians, but also in other areas. You know, should that be included in the definition of harmful material? And just for the department mentioned, you know, setting minimum standards, and just as a member state of the European Union, you know, should we be entitled to add to that in terms of, you know, in terms of more stringent regulations? And just, does the department feel that Deputy O'Leary's bill in any way is counter to EU law? And if they do, in what way do they feel that it is? And the last question I have, maybe, and it's for Facebook and the department to address, maybe, who should fund the office of the Digital Safety Commissioner? You know, in what way should it be funded? Thanks.
Deputy, I might start with, do you want to come in, Mr. Mead, first on some of those?
Yeah, sure. Deputy Stanley, thanks for the questions. I suppose the first thing to say is I hope I didn't give the impression that we believe education alone is a silver bullet in this case. I definitely, and I apologise if that impression came through in any of the presentations. I think what we're trying to emphasise in our own approach to online safety and in the collaborative work we do, that actually there is no one silver bullet to bullying or any other online safety issue. We are obviously highlighting the importance of education, and I think most witnesses would probably agree that you know, educating and empowering users is one of the key planks of any strategy on online safety. But certainly I didn't want to give the impression that we believe that education alone can solve bullying or any other online safety issue. And I suppose that's why I laid out the different themes in our own approach to online safety, which includes so education and empowerment would come in under our work in partnership with other organisations. But I also highlighted our technological innovation in terms of the tools that we work to put in the hands of users and families, and also our community guidelines. And I might ask Rachel to just talk a bit about the community guidelines on that point.
Yeah, thank you very much for your question. We, of course, don't want anybody to feel powerless to manage their safety if they're using our products and services. And as Ryan mentioned, I don't think there is one solution to these complex issues. We do firmly believe that what is unacceptable offline should be unacceptable online, and we have strong policies on certain hosted platforms like YouTube to address issues around bullying and harassment. So we don't allow abusive videos or comments on our platform. And beneath every video and beside every comment on YouTube, there's a flagging option where anybody can report content for review. Like Facebook, we have teams based around the world working 24/7 to analyse these reports, and if content violates our policies, it will be removed. And we also do work in partnership with other organisations, so we have a trusted flagger programme where individual members of the YouTube community, I apologise for using that word, I realise you don't enjoy it, but also community of users, also our non-profit organisations and government agencies are part of this programme, and these non-profit organisations are often experts in certain areas, and they're very helpful at notifying us of content that might violate these policies around bullying or other areas, and we will quickly remove that when we're made aware of it.
I might move on. Do you want to? Are you okay, Mr. Mead, with that? Do you want to come back in?
Yes.
Yeah. No, that's fine. I'll move around. Do you want to come in, Ms. Sweeney?
Sure. Thank you, Deputy Stanley. I just wanted to clarify one point, just to avoid any confusion. We have 20,000 people at the company who work on the wider safety and security of the platform, and just over 7,500 content reviewers. So those other people who make up the remainder of the 20,000 could be working on, artificial intelligence, machine learning, various technical solutions to try and keep the platform safe. You're right in that it's a very big challenge. Content review has never been done at this scale before, as I mentioned in my statement. Do I think there's a need for direct state intervention? We receive millions of reports every week. I think if the state were asked to step in to do what we and Google and others do in that respect, it would be challenging, to say the least. On the freedom of expression point, he asked the question as to whether it should be for us to determine what should be left up and what should be taken down. I think that's an important part of this conversation. Certainly when it comes to illegal content, we operate, as Trina pointed out, within the e-commerce directive framework here in Europe, which is to say that if we're made aware of content that is illegal on our platform, we have to act expeditiously to remove that. In other jurisdictions, say for example in Germany, where you have what's known as the NetzDG Act, which covers illegal hate speech, and again, illegal is an important word there, it is left to us to determine what's illegal, and I think a lot of people have an issue with that we're left in this quasi-judicial position where we have to determine in a very short period of time what's illegal and what's not. And you can imagine there's a tendency, or there could be a tendency there, to err on the side of caution given the exposure that companies are opened up to if they don't remove that content over time. So that's not to give you a concrete response, but I do think it's an important part of this conversation is if there's legal exposure for companies for pushing the boundaries on what constitutes freedom of expression, I think you'll find you could end up with mass removal of perfectly legal content that may offend, shock or disturb, but doesn't necessarily travel into the realm of what's illegal. On the false accusations against public figures, we were part of the high-level working group on false news that the European Commission convened over the summer. That has travelled some distance in that time, and it's now actually focusing more on electoral integrity, and we've made a number of commitments as part of that. Commissioner Jourova would have announced in early to mid-October what the agreed outputs were. We've undertaken to introduce additional tools with respect to electoral integrity this side of the European elections, and we're working hard to try and implement that. That's in addition to the View Ads tool we rolled out here in April, which allows you to see any ad that any advertiser is running at the same time, which is supposed to address the notion of dark ads. But specifically with respect to false accusations against public figures, if that ever drifts into defamatory territory, there's a very clear process that's in place there. We have a dedicated reporting form. I'm going to go out on a limb here and say that Google have the same, which is used to report defamation, because obviously there's a very clear process there, it can be very damaging, and so that's quite separate to reporting via our normal reporting channels, which would be attached to every piece of content on the platform. So we take that very seriously, I have to say. And then on who should fund the office, I suspect if it was funded by us, that would draw its own criticism. And I think that's probably what you were driving at.
Very briefly.
Like the BAI, that receives funding from the sector. I'm not saying that you would become the funder alone, but in the case of broadcasting, the Broadcasting Authority of Ireland, my understanding is that that does receive funding from across the sector along with state funding. But just in relation to Google, in relation to the question, you know, should a private company decide what's harmful and what isn't harmful? Just to address that.
Do you want to come in, Mr. Reid?
Yeah,
Or Rachel?
I mean, I guess the same as Facebook, we deal with this in a two-pronged approach. We abide by local laws, and if anything violates a local law, we will restrict it in that relevant jurisdiction. And then we also have developed these policies. As I mentioned, with kind of trusted flaggers and these experts, we also use them to inform these policies as well. We lean on their expertise heavily, and it's that kind of collaboration that helps us stay one step ahead. Because like the offline world, the trends that we see online, they morph and they change.
Should it be left to Google to decide what's harmful?
I think, you know, that's a very good question. I think we have a huge set of standards that are available for anyone to see. Pardon?
What's the answer from Google about that?
I think, you know, we would welcome any kind of collaboration in this space as well, and we do collaborate in this space to make sure that we are setting the correct rules, and our policies do often go above and beyond the law, and so that is something that we're very conscious of and that we take into account when developing them.
I think maybe the thing to say is that at present, as Rachel says, there is, you know, applicable law that Google applies. So that's the law that's set by legislators and so on. And then there is, I suppose, Google's own standards of what we consider appropriate on our platforms. And in the latter case, we're obviously trying to set a standard that responds to our users and responds to what society wants. But similarly, we are very responsive to what legislators...
Digital Safety Commissioner, are you happy that they would decide, or somebody, you know, that they would decide what's harmful and what isn't harmful, what's acceptable and what isn't acceptable? Is Google happy to go along with that?
I think the point we've made is that there should be a clear definition of harmful communication, and that would provide the legal clarity, not just to Google.
That's made by the Digital Safety Commissioner.
No, I think the point we've made is that we would be more appropriately made by legislators.
Yeah, so that we come with the legislation. Yeah, thank you. I'm going to bring in the department here.
Just again, I'm going to talk just a little bit about education because it was raised, and again, the private members Justice Bill and Trina will cover off the issue regarding the European Union and its requirements. Just again, I mean, Google have mentioned education, but just again, in case the action plan for online safety has taken a very collaborative approach across government because of the nature of it, and there are a number of actions in the education sphere which are the responsibility of the Department of Education, and with timelines, you know, as to when they are to be delivered, just to get the sense that this is a very broad plan, and there's an awful lot of, as you would expect, that the Department of Education is looking for. Just the second point is that in terms of some of the points that have been raised about revenge porn, there is a private members bill in the Justice Committee that hasn't been opposed by government, and that again is looking at, I'm not quite sure where it's at, but I know that is looking at some of the issues such as stalking, non-consensual distribution of intimate images, the taking and distribution of intimate images without consent. So that area is, I think, and it's probably maybe cover some of the areas raised by the ISPCC. So then in terms of I'll ask Trina just to address the European Union.
Yeah, so as the Deputy mentioned, there are two levels of legal frameworks that we need to consider, the national and the European. There wouldn't be anything preventing national law in this area, but it does have to respect the European framework and also the Irish legal framework. So one of the issues that we've sought clarity from the Attorney General's office is in respect of the Irish legal framework. Can a body such as the Digital Safety Commissioner exercise extraterritorial jurisdiction? as a matter of general principle, like where there isn't a universally accepted principle of international law. In other words, if you take something where there isn't an international norm or a European norm, can the state reasonably impose its jurisdiction on a body that's, say, established outside the state? So that would be one thing to bear in mind in terms of this. In terms of adding additional national measures, we can do that, but it does have to abide, as Niamh and others have mentioned, by the European framework around the e-commerce directive. And what that means is that if content is illegal, then it's, I suppose, provided for in that mechanism. So if someone brings a matter to the attention of a platform and it's illegal content, they have an obligation to take down that content. If something isn't illegal but might be considered to be harmful in some way, and it may be that issues in relation to, say, cyberbullying might fall into that category in some cases where, for example, there are children who are bullying each other online, but it may not be in the extreme harmful content that's going to be criminalised in relation to revenge porn and so on. That's a trickier issue because it's not a criminal matter. It may be harmful, but it's trickier. There isn't a universally accepted definition of it, and it's not provided for under the Commerce Act. So I think in terms of what's set out in this bill, if the definition sticks to criminal acts that are provided for or are going to be provided for, it's probably on clearer legal ground than if it's going into less clear territory. We will have more insights when we get legal advice back from the Attorney General's office.
Thank you very much. That's great. I'm going to bring in Deputy Lawless.
Thank you, Chair, and thanks to the witnesses for your interesting presentations today. I think this is the third piece of legislation, or one of three pieces of legislation to come before this particular Oireachtas, this particular term. And I would congratulate Deputy O'Leary in proposing and drafting and bringing it forward. Deputy Howland has a bill on harmful offence, I think it is, and of course my own bill on social media regulation, which some of the witnesses have been in on already, and some are due to come before us on in the near future. So I think there's been a focus on the online space, as I say, in this Oireachtas, which is welcome. It is fast moving, and as has been said already, some of the even hearings we had this summer are almost obsolete now because events have happened and moved on so quickly, and indeed steps have been taken both voluntarily and otherwise by the main stakeholders, which is good to see. I suppose it is a fast-moving space, and I think I suppose one thing that those three pieces of legislation have in common is they all relate to attempts at regulation, because I think we probably all agree, maybe the witnesses may not all agree, but self-regulation isn't desirable and isn't ideal. And while it's welcome that attempts have been made at different times, I think it's always stronger if an independent third-party body can actually try to impose that regulation. Just, I suppose, in terms of the specifics of the bill looks good. I've read through it a couple of times and as well in the second stage debate, or followed the second stage debate. Some of the feedback from today and previously, I suppose, goes to the heart of definitions, and the devil is in the detail. And the trick with drafting is always to get it precise enough that actually it can be enforced, but broad enough that it can be, as Mr. Mead has said, technology agnostic or platform agnostic, that it can actually be broad enough to be long-lived and robust enough that can maybe something in 5 years' time or 10 years' time will still be applicable. There's been a lot of talk about the definition of harmful communications, and I think it's probably one of the main definitions and I know Deputy O'Leary has indicated he may draft that or maybe fine-tune that as we move towards the next stages. One thing, there was also a lot of mention in the submissions to the Law Reform Commission's reports in this area and in previous studies in this area. One of their principal reports in the area, I think, was 2015, early 2016 possibly. I made a submission on that myself at the time, and one of the interesting things that came out of that was around, and it's been mentioned today, Section 10 of the Non-Fatal Offence Against the Person Act 1997 is what we call the classic harassment, which is the harassment, I suppose, pre-internet harassment, if you like. So the old stalking offence of somebody knocking at somebody's door or sending them postcards or harassing them in sort of more traditional ways. There is a school of thought legally that says that Section 10 could apply to the internet as well. And the stumbling block to date has been that the offence must be repeated, or the activity must be repeated to bring it under the definition of Section 10. So a one-off may not qualify. Certainly in the traditional world, making a phone call or knocking on somebody's front door, one occasion wouldn't qualify. Doing it 10 times or 100 times would qualify. Now, there is a school of thought that says the nature of the internet, if something is shared, so an item could be posted once, but it could be shared 100, if not 1,000, if not 100,000 times. That might bring it under the definition of Section 10, which would mean it was repeated, and that might actually be sufficient to bring a prosecution as it is. So I'm just saying, first of all, my first question is, do any of the witnesses have a view on that in terms of the existing legislation, in terms of things like Section 10, not fatal offence against the person, or other legislation that may be out there, in terms of are they sufficient, or even if not sufficient, are they adequate, might be a better way to put it. Have the DPP or any other agency brought charges of this nature to date? Have these type of issues come before the courts or come before sanction? What, if so, under what legislation? And I suppose the next kind of follow-up question is, if not, or if they have, I'd be interested in hearing about it from the witnesses' expertise. And if not, then what governance is in place? Because is it the case that there's a vacuum of governance? You know, if the existing legislation doesn't actually apply, or hasn't applied, or hasn't led to any charges, what exactly is controlling the internet at the moment in this space? And if the answer is nothing, then that's very worrying. But at the same time, it's all the more reason why we need to accelerate this bill and others like it. Just moving on, again, staying with the bill, it's very positive, it's very strong, I think it's a really good idea. One thing it didn't appear to do was to create new offences, and maybe that's deliberate. I know Deputy Howland's bill creates some offences, and maybe they can be dovetailed together so that the offences in one, or indeed the other offences that may be created in other legislation, would come under this. In terms of sanction, there needs to be a carrot and a stick. And I know there is provision in the bill for injunctions to be sought before the Circuit Court, which is useful. But I would suggest maybe to Deputy O'Leary, and perhaps it's something we can look at a report stage or committee stage when we get to that stage, that I'd like the Data Protection Commissioner has powers to go before the courts and bring prosecution. The Companies Registration Office similarly can bring prosecutions. There are many examples of statutory agencies that can bring a non-guarded prosecution. The different government departments would have similar powers. So that might be something maybe perhaps to consider to add at a later stage. I might come up with some amendments myself on that, but I might work with Deputy there on that offline, but it might be worth adding to it. And on a final note, I suppose the carrot and the stick, I think the concept of the Digital Safety Commissioner, as well as being an enforcer, as well as being a policeman as such, and I think it's in the briefing notes, and I think it's in the prelude to the bill, would also provide a sort of independent objective agency. And things like the digital age of consent, that debate raged a few months ago. I don't propose to reopen it today. It got quite controversial at times, but the likes of an external agency which is not connected to any of the different platforms nor any particular party or anybody else, probably would have good status to make recommendations on those kind of issues that I think would get good hearing and get good traction across the board. So I think that's a great opportunity. I think it's in the bill already that would be envisaged as a sort of advocacy role and sort of expert role that would be very useful. So that's just to say a couple of questions, particularly just I suppose to recap, particularly in terms of what legislation. I mean, there's a question mark around Section 10, whether that exists, whether that can be applied at the moment. Are there other existing legislation that apply? And if not, are we in a total vacuum? Or what is the current legislative framework that these kind of offences, if they exist even at the moment, can be prosecuted under, or what has been the case, the experience to date? Thank you.
Those questions are mainly for the department.
Whoever can answer.
I might bring in Ms. Cronin. Do you want to?
Sure, yeah. Just, I suppose as you say, we've gone to the Attorney General's office looking for the definition of harmful. So we can obviously bring to their attention the Section 10 section that you've mentioned, Deputy, and ask them would they feel that that's relevant, and we can do that, and obviously we'll get a response there. In terms of the DPP, and it's probably more the Department of Justice, because this department is in the space really of illegal digital content. So I don't have the answer to that, to be honest. And in terms of, Deputy O'Leary, we've obviously gone to the Attorney General's office on various aspects of the bill and are awaiting their advice, but we didn't ask about offences or sanctions. Maybe Deputy O'Leary.
Do you want to come in on any of those?
Yeah, just a few points there. In relation to Section 10, I think Deputy Howland's bill would have addressed updating Section 10 of the 1997 Non-Fatal Offences Against the Person Act, and that's a bill that we supported. And I think that does need to be updated. I think it is out of date. It hasn't taken account of, obviously, very significant changes that have happened. In relation to the offences, I suppose both Deputy Howland's bill and my own had their origins in the Law Reform Commission paper that was produced, I think, in early 2016. And in drafting and taking I suppose, the proposals that the Law Reform Commission had, I was conscious of the fact that, this is a specific proposal in terms of establishing an office and giving it a remit and so on. I'm open-minded, but I'm not sure that this is a suitable bill, even though I support the updating of those criminal offences and additional criminal offences. I think it might complicate our work in trying to establish an office, giving it a remit, the codes of practice, national minimum digital safety standards. I think if we were to, and I'm open-minded on this, but my initial view is that if we were to try and introduce criminal offences into this and enters into the area of being a criminal justice bill, I think that our work could become complicated. And I suppose that's relevant to the view that I take in relation to the definition. And I suppose, if you bear with me, in relation to the harmful communications, I spoke on the last occasion in relation to what that might involve, and I outlined that in general this would include distribution or publication of an intimate image of another person without consent, threatening to do so, the taking or distribution or publication of an intimate image of another without consent, distribution or publication of an intimate material where this seriously interferes with privacy or causes harm, distress or harm, alarm, distress or harm to the other person, distribution and publication of threatening, false, indecent or obscene messages to or about another person in circumstances where this is done for the purposes of causing alarm, distress or harm to the other person, or is done persistently communicating with a person in circumstances which seriously interferes with the other person's privacy or causes alarm, distress or harm, or any other inchoate behaviours related to the above. And the point in relation to that, as I say, I'm working on the drafting of how you'd actually structure that. I think we should be looking at the behaviours, and I take on board the point and consistency with the e-commerce directive, but I think that when we are asking the Commissioner to take down material, we outline to them the behaviours and not ask them to adjudicate, and indeed the providers, not ask them to adjudicate at that point of takedown on whether it is illegal or not, because I think there are behaviours that would be close to the line, and you still may need that would be removed as quickly and the person gets redress as possible. So I think we should look to the behaviours rather than seek to state that these matters are illegal, you should remove the illegal content. They're required to do that anyway under the e-commerce directive, and in many instances are doing that competently. So I think we should be targeting behaviours, and I suppose I agree with the point in relation to an independent external agency. I think that's important, and I think that's the principle I think in which we're all largely agreed. And I think it's also, and I made this point at the last committee meeting, this is an organisation where it's constantly in communication with the providers, the platforms, but also receiving complaints where they're unhappy with how the providers and the platforms are addressing matters. They're going to be the first to know, I think, of the changes in abuse and harassment and all these harmful communications. They'll be in a very strong position, I think, to advise government on any future, whether criminal justice approaches or policy approaches, Department of Education and so on, all that kind of stuff, changes in curriculum, perhaps even with the NCCA, and I think they'll be in a very strong position to do that.
Thank you. Does anyone else want to comment on that? I might just go to Deputy Ryan and we can bring... Yeah.
Platforms would know if they've been before the courts. That's probably something that they would be aware of. So have you had any experience? I mean, has any, be it Section 10 or anything else, has that been used? You know, have any charges been brought of that nature? Have the platforms been involved, if not necessarily as the defendants, but have you been, you know, as a third party, or have you been in the court, or are you aware of any existing legislation in an Irish context being used in this area to date?
I'd have to check. I'd also be wary of getting into a conversation about Section 10 of the Act, given that you're a lawyer and I'm not. But I'm not aware, but I would have to check. My understanding is that there is a view out there that Section 10 does apply online, but that it just hasn't been tested in many instances. And so I think, as Deputy O'Leary said, that was the ambition of the Law Reform Commission with its draft bill, which Deputy Howland has moved forward with, to make that more explicit. And as I said earlier, we'd be supportive of that, although I did include where it's clearly defined and practical for the digital environment. And I think that's where you get into a situation where what's harassment, because there'd be very different views on what the threshold is for different individuals. And so I think platforms would need very clear guidance on where that line is drawn, so they would, I suppose, have legal certainty.
Mr. Mead.
Yeah, I mean, again, like Niamh, I'm not in a position to give you, unfortunately, a legal commentary on the Section 10, and I don't, unfortunately, have, specific cases that might have been before the court. But as a general matter, I suppose, as I said in my opening submission, our view would be that what's unacceptable offline should be unacceptable online, and similarly, if there are offences that are clearly defined and apply offline, we would support ensuring that there is a corresponding offence online. So I think we'd support the spirit of ensuring that if there's an offence of harassment, that it also applies online, and if there are any particular gaps in that, we think that'd be worthwhile doing. I mean, I suppose in terms of a case before the courts, we do obviously have procedures for law enforcement to engage with us when it comes to, gathering evidence for offences and so on. So I can provide some more information on that at a later date as well, if you wish. But I suppose, if there is a clear offence, then we can cooperate to help in the prosecution.
Thank you. Deputy Ryan.
Thank you much indeed for the most interesting discussion, important discussion. I was very interested, Mr. Church, the horrific example you gave of the young girl whose images were shared by a former boyfriend. Is shocking, but there's a wider concern that in this 10-year increase in the demand for your services, there's also been, it would seem, in the last 10 years, a significant increase in level of depression and other psychological problems among our young people. And a lot of reports that I read, and I must admit I've spent the last hour frantically reading as much as I can on the internet via my own device, but that there is a correlation between that increasing level of young depression, anxiety, other mental health difficulties, with the correlation with the increase in amount of screen time, the amount of young people are online, and that the bullying might not, or that the harm might not be just in that very obviously graphic, terrible example, but in all sorts of subtle ways where exclusion or other mechanisms which affect mental health. Do you make, or indeed your other colleagues who have presented here, do you make that direct connection? Do you attribute well, if it is scientifically, which everything I read in the various psychology sources, that there is that increasing level of depression and anxiety and mental health problems, particularly among young women or young girls, it would seem, that we can make the correlation, do make the correlation with increased use of the online streaming service, particularly with mobile phones? And that's the first question I have. The second question, it was very interesting, Ms. Cronin, in terms of obviously things have developed a lot recently with the passing, as I understand, last month by the European Parliament of the Audiovisual Media Service Directive, the revision of it, and I presume it's a foregone conclusion the Council will be approving it before Christmas. And the reality that, as I understand, something like 80% of all online content now is video. Are you saying in your contribution that in terms, if you're looking for locations for regulatory bodies to manage some of this, that something like the Broadcasting Authority of Ireland, which has a lot, given that they're already involved in the audio media regulatory environment, and given that the report from the European Parliament was very similar to the issues that be concerned here. It really did very strongly focus on the effect of online media services on young children, that might make it the case then, if we're looking for an institutional body to house regulation, that the BAI might be a suitable. You could look at the Data Protection Commissioner, you could look at creating a new agency, but that the BAI might be best placed, given that they are so versed, as it were, in that audio media. And given the difference now between media, online or broadcast, what's the difference? In fact, for young people, it's all not all, but vast majority is increasingly online. And regard to, so I'd be interested to hear your views on that. And then for the companies, I'd be very keen to hear, I mean, in that report, that text from the Parliament last month, in subsection 20 of their report and subsection 21, they're calling for the potential for the use of encryption and much greater parental control mechanisms to protect young children. And in, I think, their text bullet point number 21, they say that personal data of minors processed in the framework of technical child protection measures should not be used for commercial purposes. Does this not call into question your whole commercial approach in the processing of data, for minors particularly in this case, that this has to change? As Tim Berners-Lee said yesterday, you're damaging or causing a threat now to the internet and all the benefits that it does bring, and they're immense, but that your commercial model has to change. And should it not change first and foremost with the if you're to live up to that direction from the European Parliament, from the new Audiovisual Media Services Directive, how can you do that if you do not know with absolute certainty as to the age of the child that you're dealing with? And that the current mechanisms you have in place, we've heard in previous evidence, clearly doesn't do that. You cannot tell whether a child is 13 or 15 or 16 or 8. Or you can say you do, but you don't have the effective commercial mechanisms to do it. So does this not reach us at a point in time with this new directive that you have to set in place new mechanisms to guarantee to know the age of the minors who are on your network so that you can live by that commitment not to use the data for commercial purposes? How can you do that if you don't know if it's a minor? And I suppose, Ms Cronin, in that regard, you said in your own submission that indeed age verification does look like now one of the key new regulatory requirements we're going to be seeing as a result in your own contribution. I don't know the exact wording now, but if I heard you correctly, or read you correctly, Ms Cronin, that sort of inclusion of age verification may well be one of the new regulatory measures that we're looking to put in place, which I would very much welcome, given the evidence that Mr Church and others has presented here in terms of the health implications of some of these, the use of some of these services.
Thank you. I might bring in, do you want to come in, Ms Cooney, or ISPCC, whoever?
Yeah, I'll just kick off. I mean, I suppose the short answer, Deputy Ryan, is that there is no research to prove that correlation. However, as I said in the opening address, we take, and in answering other questions, we take an awful lot of calls every day. I mean, it's 1:05 now. I think our child line has probably received over 500 calls today alone. So, you know, I'm new to this. I'm only 3 months in the job, so quite a bit of my time was listening and actually shadowing some of those calls. And I've only relayed one case example today, but there are hundreds which are out there. So what we're certainly seeing, and from talking to the volunteers online, is behaviours, as you described, that are causing significant issues for the child. So exclusion, real subtle things, as you mentioned, exclusion from not being invited to a party, not being part of a WhatsApp group, which in effect it's bullying in itself. So I think I mentioned earlier that we're going to have to start looking at how we categorise those calls. So if a child mentions in a confidential call that they're being subject to online bullying, that's categorised as online bullying. But the conversations, and far more conversations we're having with children every day, are issues that they're having relating to online issues. So what we would certainly love to see is a lot more research around that. And if it is a correlation, intuitively, I would agree with you, but there's no research to show that, and none that I know of anyway. I do think, though, and I also mentioned, we are seeing a slight decrease in telephone calls. By the way, it's young boys who are calling online, which I thought was interesting. You tend to think it would be girls calling, and because they're better at conversing sometimes, but the boys seem to find the online calls a great source of support. But we are seeing the switch from calls to online chat. And this has really forced us to upgrade our own online platform, and we're launching it actually next week. And I think with that launch of our new online platform, you can get into an awful lot more in-depth conversations, and that's when we will start gathering an awful lot of research around this.
I just wanted to add, just in talking to teachers and principals on a regular basis, they're definitely seeing the fallout in the classroom. You know, children coming in tired, children that falling out over cyberbullying incidents or gaming, or, you know, there's a clear dynamic. And I was talking to a principal yesterday, just in preparation for Anti-Bullying Week next week, and he was saying in the 10 years that he's been a principal, the change has been so stark. You know, obviously as a principal in the early years, he was dealing with bullying, but it's the amount of online instances that he's now having to deal with is just incredible, and what that impact is then in the schools on a day-to-day basis. I mean, as our survey showed, you know, teachers are dealing with this all the time in the classroom. So I'd say just anecdotally, there's good evidence. There was a survey published this year that found that girls, this was in the UK, girls who are using social media at 10 for an hour a day are far more likely to have social and emotional problems at 15. And that was a 5-year longitudinal study. So I think some evidence is starting to emerge. Certainly the kids we're talking to are all in primary school, and they're valuing popularity over privacy largely. So they're not really understanding the ramifications of sharing, you know, all sorts of things, dick pics, you know, intimate images, children being told to kill themselves because of the colour of their skin or because of the way they look. You know, there's lots and lots of harmful communication, and I think that online-offline balance, you know, how you're treating people in real life versus how you're treating them online, is not well understood, and definitely we need to, which is why we keep going back to this education piece.
Thank you. I might bring in the department, Ms. Cronin.
Just to say, Deputy, just to bring you up to speed, is that the AVMS was actually finalised this morning at a meeting, so you're getting the news. So in terms of, I mean, the scope of it, as you mentioned, a regulatory body will have to be established. As you say, it's either a new one or an existing one, and clearly the BAI is in the frame for that. But I mean, what we're doing is, because this is such a new area, that we're actually taking the opportunity in the department to travel and meet actually a lot of other member states to get a sense, because it's a big area, clearly, with the platforms that we have in Ireland. The AVMS will be of particular significance to Ireland, so we're keen to get, you know, to learn from other member states how they're managing. We've met the UK, I know, about to depart maybe, but we'll be going to the Nordics as well, just to get, we really want to go very broadly on this to make sure that we get it right, because it's a very significant decision how we regulate this space. So in terms of the age verification, the directive itself, I mean, talks about minors, protecting minors from audiovisual, protecting the general public, and protecting the general public from advertising, dissemination of which is a criminal offence, terrorism, child sexual abuse, and offences of racism and xenophobia. And that the model proposed in the directive is a co-regulation model between the platforms and a regulatory body. But part of that, because it does talk about minors, you're right, we will have to look at age verification and parental controls, but we have 21 months to do the transposition, so we really are going to be very, very thorough in how we do this and try and get it.
The same way on advertising, we do it on a time basis, so you can you survey, but the current system, you'd agree, doesn't provide online video streaming, where time doesn't provide. We don't have an effective mechanism for age verification. Is that your agreement?
Well, that's certainly something we have to look at in the context of doing the AVMS. This age, yes, that's an area we will be looking at.
And I might bring in Facebook and Google to... Will I bring in Ms. Sweeney?
Sure, yeah. I'll just address each of the issues you raised in order. On the wellbeing front, there isn't a huge amount of research. We've commissioned some in the UK recently through a think tank called Demos, and I think one of the main findings that's coming out of that research and others is that it's less about the amount of time and what they're doing with it, how passive scrolling of content can be damaging in some cases, where meaningful interactions can actually boost your sense of well-being. But there is a dearth of research there, and we're trying to address that. But you'll see on Instagram in particular, it has a very strong focus on well-being. It has a whole dedicated section on that. It's introduced certain tools to help you limit your screen time, keep track of what you're doing. Apple has a report that you might see flash up on your phone if you're using an iPhone that gives you a sense of how many notifications you've had, how much screen time you've had per day on average. And we are also, as Facebook, looking to roll out time spent type of well-being tools. I had thought they would be rolled out by now, but we're waiting for confirmation of when that will happen, but it is something we're thinking about. I need to admit, I don't know which European Parliament report you were referring to, so...
It's 3rd of October, the text on the audio-visual media services, when they agreed...
The actual directive itself? Or...
Yes, in forward to that.
Okay. So we are looking ahead to how that will apply to us. We are actually meeting with the BAI on Thursday, even though it's a little early for that, but they asked us if we would meet so we could start to get a handle on some of the challenges ahead if they do end up in that situation. Obviously, the guidance that will follow the actual directive should be issued sometime towards the end of the year in terms of determining what the principal purpose of a service is when it comes to video sharing platforms. So I think a lot of this will only really take shape when those guidelines come out. On the issue of age verification, it is a challenge, and this is something I've talked about here before. One thing that did come about, one change that did come about on our side on foot of the dispatches programme that you'll recall we were in talking about on August 1st, is that prior to dispatches we used to act with respect to underage accounts when we would receive a report. And I'd encourage everyone here, if you're aware of under 13s who are using Instagram, Facebook, please do report it to us because we will take action. But we used to wait for a report. Now, if we have any reason to believe that the user is underage, we'll checkpoint that account, meaning the person must provide identification to regain access to it. On the ads front and the commercial model, under 18s are protected from certain types of ads on Facebook. For example, ads for gambling, alcohol, certain types of health products, diet pills, dating apps, those sorts of things won't be surfaced to them in their news feed. So that there are some protections in place for under 18s on that front. But I take your wider point about our commercial model in general. It is an ads-funded free service, so that doesn't give me much wriggle room on making concessions to you on the commercial model today, unfortunately.
Bring in Mr. or Rachel Madden.
And there are kind of three things that I'll address here. One is, the first is parental consent. As Ryan mentioned, last year we launched Family Link in Ireland, which is where a parent can kind of stay in the loop as their child uses their device and their Google account, and they can set some digital ground rules, screen time rules, like a bedtime or daily device limits, manage the apps that they can download, restrict websites and so on. When it comes to ads, these users who have accounts managed with Family Link, we have prohibited personalised ads, so there's no personalised ads for these users. And the same with YouTube Kids, which is our product for young people who want to use YouTube. There's no personalised advertising on YouTube, and we've stricter policies. So in YouTube Kids, and again for young people who have accounts managed with Family Link, there are no ads for food and beverage. There's no ad for health or beauty products. And with any advertisers using Google services, they cannot specifically target anyone under the age of 18.
And the fundamental problem is you can't, in truth, verify the age.
Absolutely. That's a really important question and something that we think about a lot internally. I think it's a really difficult problem. We want to strike the right balance, which is where we can confirm someone's age, but not ask them for additional information like a copy of their passport or government identification. Right now, if you try to set up a Google account and you're under the age of 16 in Ireland, we will say, go get your parent, you should use Family Link, which then
force you to change. Does the concern about underage, will Google's business model not be forced YouTube to have some mechanism, rather than it being free and paid for by advertising, will you not be forced to change your business model so you do start to know what the age? Because otherwise everything else is all just, you have no protection.
Yeah, and we think it's something that we're definitely thinking about a lot, how we can verify age in a more robust way. And right now I think our mechanism is to direct to Family Link. But I absolutely acknowledge the concerns, and there's definitely more we can do here.
Thank you. I'm going to bring in...
One last point. If Facebook could please improve the level of well-being in the Facebook comments that I get from that community of people who like me and follow me or whatever, God help us, we could do with it.
Yeah, thanks, Chair. I'll be very brief. I realise it's pushing on. First of all, I'd like to acknowledge that the bill came forward through my Corkonian colleague down in Cork, and in fairness, now it's a very, very important bill, and I think he's the fingers on the pulse, and it's an important piece of legislation. I do think, though, Deputy O'Leary, that the issue of the definition is probably going to be the defining factor in the bill itself. And I think your work on that issue is something that we need to see at some stage, because how this is going to be defined and drafted regarding defining the actual criteria where this is going to go is very, very important. You gave us a brief outline a while ago, which is important. I would welcome the actual text of that document when it's ready, because that will give us the basis to actually move forward in many ways regarding how implementable the bill will be. And I think the biggest issue, there are several issues here, I think, but future-proofing this bill is going to be a huge issue, so we'll have some kind of longevity. We've seen dramatic changes in this industry in the last 3 or 4 years. I'm sure those changes are going to increase over the next few years in particular. So I just think how we're going to frame it so it can be future-proofed is something that we all need to look at, so we can actually ensure this bill will have a lifespan that it actually desires. Could I ask the Department, in particular, just one issue regarding, in particular, Trina was mentioning the issue of the European legislation versus the national legislation and how they intermingle. Could I get a kind of more up-to-date view regarding, if you had a company based in Ireland, a global giant of any nature, how would that legislation, a legislation based in Ireland, have an impact on the European Union and the 6 million people? In other words, if we had this bill enacted, is it for the 4 million people who are based in Ireland, or would we be taking a European view of it's a European headquarters, information coming through this European headquarters is Irish information, and then you'd be looking to police the whole European network off of this actual legislation itself? Or are we really going to be stuck with a piece of legislation that will, in many ways, look to solve an Irish issue, but unfortunately the global content still could play a part in that, and how could we police the global content coming into that circle itself? Because, look, we all have friends all over the world and so forth. Like, how will this interaction happen? Like, how could you post in another jurisdiction and come into this jurisdiction, and who's going to police it? Is it the place where it's posted? Is it a place where it receives? Or where is all that tied in together? Because we are very much a global entity itself. And could I turn to the actual providers themselves, or even the actual charities that are here, regarding the ads that we have on the Facebook or the Googles in particular? And I mentioned the ads that are there at this time of the year, especially since Halloween is over, the Christmas ads which have materialised on my iPad that my daughters use on a regular basis regarding children shopping, regarding Santa Claus, all these issues. Is that the real kind of market you're chasing when you look at, in particular I look at Google Kids, which would be very popular in my household, that kind of market? And do you feel that there is a kind of major drive to get commercial gain off of your platform, looking at the actual children that use this? Because the first 30 seconds of whatever they're going to watch is going to be an ad about whatever. And do you feel that is an issue that you need to be looking at, because it's quite invasive, it's in your house, it's literally, the shopping list is done for Santa already off the back of it, and do you think that is a big issue that we need to look at and address, that kind of information coming in is something that we should be screening out at some level? Thank you, Chair.
Will I start with, do you want to, yeah, okay, Trina.
So, Deputy, I would distinguish between European legislation, such as the Audiovisual Media Service Directive that my colleague referred to, and this piece of national legislation, where you have European legislation, it applies throughout the European Union. So, for example, we will be regulating Facebook and Google insofar as they fall within that directive for all content throughout Europe, because they are established here. However, in respect of the Digital Safety Commissioner Bill, that's national legislation. So the issue that arises, there's a couple of issues. One, if there is content that impacts on an Irish citizen, but the company isn't established in Ireland, I think there are real concerns as to how that could be brought within scope, or whether it could. And that's part of the advice we've sought from the Attorney General, because it's extraterritoriality is a factor there, and Irish law may not have a reach in respect of those companies. So unless Europe were itself to legislate for something similar to a Digital Safety Commissioner, you're not going to have a European reach in respect of this legislation. Now, it may be that, particularly in relation to criminal, illegal content, Europe is moving more and more in that direction, and there's a new terrorism regulation underway at present. But for content of this nature, Europe hasn't as yet got into this specific area. So there are certainly extraterritoriality issues to be considered in respect of this bill, how far it can apply or should apply under Irish law.
Thank you. Deputy O'Leary.
I want to stress a few issues, and I suppose I thank Deputy Lombard for his kind words, and I suppose we're a long way from County Council and discussing who's responsible for cutting the ditch and the verge. But
that too.
Huh? I still get that too. Yes, indeed. Yeah. I suppose just on a few of the issues, like, I mean, I take on board the point that you've made in relation to the definition, but I think that's the value of this process, that it actually allows for discussion and teasing out of all those issues. As I say, there will be a drafting. I have a general sense of it already, but there will be a drafting the committee will get. But I repeat to any of the other organisations that are either here or listening in, if they have a view that I think it would benefit the committee, either a general indication of what they believe the definition should be or a specific drafting, I think that would be of value. The future-proofing point I think is important, and that's why I think this legislation is largely focused on the principles, the procedures, the structures and so on, rather than necessarily going into specific technologies or specific forms of communication, say for defining, as we have to do, what a harmful communication is, and largely in terms of the harm that it does. Obviously, at later stages, it will have to be revised, as any legislation will be, but I think it does outline the framework and principles fairly well. And in relation to the jurisdiction, and I suppose I addressed it in I addressed it substantially enough in the last committee meeting. I won't go over the full text of what I stated on that occasion, but I do believe, like, the extraterritorial effect of this bill is not particularly radical. It's limited to situations where the communications affect an Irish person ordinarily resident in the state, and the means of communication used in communication with such harmful communications are within the control of an undertaking or company established under the law of the state, or where such harmful communications affect an Irish person ordinarily resident in the state, and where the means of communication are within the control of an undertaking established under law in another state, and where a court established in the state would have jurisdiction to give notice of service. I suppose, like, I mean, I would make the point as well, like, I mean, I believe, and it's outlined, and I can send you correspondence on this, that this isn't particularly out of line with other legislation that exists in this jurisdiction for extraterritorial effect. But, like, I mean, some of what this bill aims to do is to undertakings would have certificates of compliance if they're compliant with Section 4 and 5. And it's my view that it would be desirable for any significant platform undertaking to be seen to be compliant. The users, and particularly parents, would be aware that this was compliant, and if something is based outside the jurisdiction and they want people in Ireland to use it, then they're going to have to reach standards to reach that certificate of compliance. So I think it would be possible to bring, to give notice and to initiate proceedings. There are some difficulties that probably need to be sorted out, but I do think that the whole process certificate of compliance is of value in that regard as well.
Okay, I might bring in the social media platforms in relation to other questions by Senator Lombard, in relation to advertising ads. Do you want to respond on that?
Yeah, thank you for the questions. I only noticed myself on the 1st of November all the Christmas ads on the television. I was up in Dundrum on Sunday when I got back and saw all the Christmas decorations. I thought, oh, it's here. I think, you know, most of our services are ad supported. YouTube Kids we made the decision to offer it as a free app, so everybody could have access to it. We have, as I mentioned earlier, stricter ads policies, but there are content creators who invest a lot of money and time themselves trying to develop this fun and educational content. We have to find a way to fund them. In Ireland, there is YouTube Premium, which I think is about $11.99 a month, and that carries over to YouTube Kids, so you can get a non-ads version of YouTube Kids under a subscription service. But these are important questions, and I think we're trying to strike the right balance with the policies that we've developed for YouTube Kids while also being able to offer the app to as many people as possible.
Okay. Does anyone...
I've kind of forgotten what the question was. I'm really sorry about that, but I think what you were driving at was the kind of advertising that...
Is it of children?
So all ads that would be placed on Facebook are reviewed either through human review or automated review for the nature of the ad, but we'd be agnostic as to what the product is or the service that's being sold. Like, there's no particular courting of certain type of advertising, if that is okay.
If anyone else has anything to add before we wrap up? Yes.
I do actually have one thing I'd like to add. It just refers to the August 1st hearing. I wanted to correct the record on one matter. It's a small issue. I don't know that it will be of major concern to the committee, but at one point in time when Deputy Dooley was asking us about training materials that were being used at our outsourced partner CPL for the training of content reviewers, we had been given to understand that the training decks or the PowerPoint decks that were being used had been changed. As part of the investigation that we've carried out in that interim, we're now clear that they weren't changed. It was kind of hard to figure out the context of some of the material that was being shown in the programme because we didn't have the before and after, but that was an example that had come up in the course of somebody's work, and they were taking a second look at it as a team, so it wasn't part of the normal training materials that had been produced. But I just wanted to make sure that that was corrected on the record, because we did give you the impression that it had been changed, and that wasn't the case.
Okay, thank you for that. I want to take this opportunity to thank all our witnesses for coming in today. I think it was a very good exchange, and it's proposed that the committee will publish the opening statements and the submissions received to our website. And if there's any further information that you want to pass on to our committee, we would greatly welcome it, especially around those definitions of harmful communication and anything else you feel would be relevant to our work here on this bill. So we'll publish those statements and submissions to our website. Is that agreed? Agreed. So the Joint Committee is adjourned until 4 p.m. on Tuesday, the 27th of November at 2018. Is that agreed? Agreed. Thank you. Thank you very much.